When you woke up this morning, did you think you were going to be testifying in a murder trial?
No, Your Honor.
Very well. State your name and your position.
My name is Elizabeth Sensi. I'm a pretrial services officer with the Court of Common Pleas.
Very well. And is the normal course of your events, do you administer drug tests to various defendants?
Yes, I do.
Did you administer a drug test through a urine sample to Ms. Rebecca Kinner?
I did, Your Honor.
That was just moments ago?
It was.
And that was at my direction?
It was.
And how do you go about conducting the test? Not taking the sample, but once the sample is obtained, let's start there.
Once the sample is obtained, I make sure that it's a valid sample, that they provide enough for me to test. I then dip a instant test stick into it. I used a 4-panel stick. I let the stick sit, make sure it does not touch the plastic as instructed. Then I cap the stick, I lay it flat, and I wait for a result to show.
And that's what you did in this case?
I did, Your Honor.
And you followed your training. First off, have you been trained in the use and administration of this test?
I have, Your Honor.
And you followed your training?
I did, Your Honor.
What did you do?
I'm sorry?
What was the finding? What did you read on the test kit?
The results were all negative, so I saw 2 lines for each of the drugs I tested for.
What drugs are, it's called a 4-panel?
It is a 4-panel.
What drugs are being tested for?
THC, which would be marijuana, cocaine, methamphetamines, and opiates.
And they were not present?
They were not present.
Very well. Any questions of Ms. Sensi?
No, and thank you for your attendance.
Did you? Chief Schiavone?
Yes. Just so I understand, you did not test for Prozac?
Unfortunately, the instant test sticks, there's nothing that Prozac would show for it, considering it's a non-narcotic.
And how about the nickel?
That would not show on an instant test stick as well.
Thank you, ma'am, very much. So you tested for the drugs of abuse?
Yes, sir.
Street drugs?
Yes.
Marijuana, cocaine, methamphetamines, that type of drug?
Yes.
Yes, ma'am. Thank you so much. Thank you, Judge.
Prosecution?
No, thank you for asking, Your Honor.
Normally, over the years, I've seen that persons, before they administer the test, might ask the subject of the test, have you taken any drugs? Did you ask her?
No, Your Honor, I did not have any conversation whatsoever. I just instructed her to please hold the cup with both hands so that I could see both hands were on the cup, and that was it.
Well, Ms. Sensi, thank you very much for your time. And is this the first murder trial you've ever testified in?
Yes, Your Honor.
Very well, you're excused.
Thank you.
Would you like the Sensi to maintain the sample and the stick if she disposes of it?
I don't intend to maintain the urine stick sample unless someone else wishes to. If there's a request, we will.
We would just ask that the results be attached to the record.
Well, those were the results.
I didn't know if there was a written result. It's strictly a stick. Then the testimony, I would say, would preserve the issue, Judge. Thank you.
I am satisfied with the testimony. Thank you, Ms. Sensi.
Thank you.
All right, we've concluded now the evidentiary portion of this competency hearing. The defense has the burden. The witness is presumed competent. Is there any argument that the defense wishes? I'll let you go first, in other words. Is there any argument that the defense wishes to present?
Yes, sir. If it's the court. Judge, I don't know that I've been in a more pivotal situation in a trial. The court fully understands the importance of this witness. This is the sole witness for the state of Ohio.
We'll strike that, Your Honor. I apologize to the interruption of the argument.
No problem.
I'll just
court has a full appreciation for the importance of this testimony. This is the key testimony in the case by the key witness in the case. It's virtually the sole and only evidence that could be used by the jury to convict Bradley Young. The court has heard the answers to her questions that were propounded by the court, by the prosecutor, and by myself. Your Honor, I believe the answers to her questions make it clear that this witness is not competent to testify. Whether or not she knows the truth, we don't know, because she answers both ways. Whether or not she knows the difference between a lie and the truth, I'm not sure she does, because her answers are just so inconsistent. Is she able to reasonably relate facts and circumstances to this jury? I would say positively not, Judge. I realize there's a presumption of competency. And this isn't a situation where the evidence is even close, Judge. She thinks the moon is made of green cheese, but then she said that's not true. She only answered that way because Mr. Moser asked her the question in such a way as to suggest the answer. And she went with it. I think that alone, Judge, would be enough. Your Honor, I'm moving to strike her testimony, and the alternative, we're moving for a mistrial. Thank you.
Well, it gets a little premature. We're going to take this a step at a time.
Yes.
At this point in time, I don't know, found incompetent, and we'll argue about what happens next.
Yes, sir.
And I think it's best to take this a step at a time.
Yes, sir.
Stay alive.
Yes, thank you, Your Honor. To characterize this witness as the most important sole witness, as if she's the end-all, be-all of this case, is a misstatement. If she was on that moon made of green cheese and could never appear in this court, the state of Ohio's case would just be as rock solid as it is.
I'm glad to hear that. Now, on the issue of competence.
Right, I know, and that was where my objection was, and I appreciate the court's opportunity to respond to the characterization. Now I'll get to the issue of competence. Thank you for that opportunity, Judge. I do appreciate that. She has been determined by this court to be competent. You would not have entertained her plea with respect to her earlier investigation for the psychiatric, psychologicals, or whatever that you had at that time to determine that. Now, has she somehow become incompetent since that time because she is taking substances, Lamictal and Prozac? There is no evidence presented to this court of some synergistic effect that those drugs have any effect on her competency at all. It's been suggested without proof. What there has been in this court, however, is cross-examination. Cross-examination that ordinarily takes place in every single trial. Sometimes the cross-examination goes nowhere. Sometimes on cross-examination, a person is able to, the examiner is able to get a person to admit that, yeah, I'm that person that goes along to get along. And every skilled presenter of evidence always discusses the go along to get along problem. Everybody knows, every trial lawyer knows, that the pitfall of an aggressive cross-examination is the witness that says, okay, all right, what the heck? If you're saying the moon's made out of green cheese, okay, get off my back, I'll agree, it's made out of green cheese. That's what cross-examiners do in front of juries. This case is in front of a jury. They are asking you to make a predetermination of the effect of the cross-examination that they have the right and the ability to do, and they've got plenty of ammunition for it. They could have that same opportunity in front of this jury that they've had with you, but at this juncture, They want you to assess and determine her credibility on cross-examination before the jury gets a hold of it, as if she's somehow incompetent to tell the truth, based upon some competency medical issue, which she has no evidence of having an effect on her ability. Does she lie? Somehow or another, she interprets that a false statement is a lie. In her mind, perhaps it's not. In her mind, it's go along to get along. They have the opportunity to test that. And if they can destroy her, absolutely crush her, that's what juries are for. That's what cross-examination does. And good luck. Okay. But not at this point, Your Honor, to throw this case out on a mistrial, or say that somehow the jury doesn't get to hear any more from her, or to take her testimony from yesterday and toss it out the window. No. They get to do that in the jury room. Now, at the end of the case, maybe the court will have to assess her credibility at the end of the case and see if that had such a material effect on something. You can't do it at a 29, we all know that, but maybe you can at the end of the case and assess credibility. The credibility issue comes about as a process of cross-examination. And credibility has the determination of whether or not somebody's lied willfully on a material fact, as opposed to whether or not the moon's made out of green sheets. All of these things are for the jury's determination on cross-examination. Does counsel have the ability and the right to inquire about her truthfulness? You're not going to hear me objecting to that. And destroy her, crush her, do whatever they do to her. They'll be able to do that. They get to do that. Sometimes, just because cross-examination is so devastating doesn't mean that somehow you get to throw the case out on a mistrial, or take it away from the jury to understand what she said or didn't say, and what was true and what was not true. So, that's the point I'm trying to make, Judge. I don't want to start repeating myself. But I think that it is not appropriate at this juncture to determine that she has lied in such a way that you now can make that predetermination before the jury gets to decide whether or not they can listen to her testimony on cross-examination, or the testimony she gave yesterday on direct.
What does it mean in Rule 601 when it talks about those persons who appear capable of perceiving facts relating to the truth? Isn't that what she said today? I'll just answer any old answer, even with you today. I'll give you any answer Stephen will. With no filter as to whether it's true or untrue. She realizes it's untrue.
I still think it's a jury determination, Your Honor, on cross-examination on whether or not it's something material in this case, and whether she actually lied about that. I mean, at this point, Your Honor, by the way, I don't know specific things they are referring to that are material to her testimony yesterday and or today that she was actually saying a mistruth to go along to get along. She said, actually, that everything she said in the State's presentation, which is relatively brief, was true on the material issues in this case. Now, did she give oral sex to this guy in some issue a couple of years ago and she forgot that? Is that something that she might want to forget? I suppose maybe so. Is this case about the sex lives of 20-year-olds? I hope not. But I understand that she would have some hesitancy probably in a courtroom full of adults and people talking about her sex life somewhere along the line. Did he bring it up that she actually really did say that? And she did say that and thing? And she said, well, I don't recall what I said on the Facebook page. But yes, she did. Apparently, they got it. We gave it to them. They ought to know.
She doesn't seem to really competently think about whether it's truthful or untruthful when she responds to a question. If one knows that they're testifying untruthfully and they've got an agenda, then I don't know that they're necessarily incompetent. Because they're able to, if they've got an agenda, they're thinking about what they're doing, and they recognize the difference between the truth and a lie. One man's truth is another man's lie. She, on the other hand, doesn't even seem to go through that process of necessarily having an agenda she relates, and she just gives the first response that comes to her.
Well, not with the direct examination, because we asked open-ended questions. We didn't lead her and not permitted to lead her in her direct examination. So she gave her answers without being led to the green cheese. The defense does. They led her to
You
whatever they
asked her a
want.
leading question, you, the prosecutor, a leading question, was the moon made of green cheese? And she says, yes.
As an example, absolutely.
And she said, yes, Mike.
Mr. Murphy.
You said, yes, you do.
I don't know that I saw it in exactly that. I thought she was using that as an example of how she goes along to get along. And as she said, yeah, I know things are made of green cheese. But if I pressed her in that, would she say, yeah? And she said, yeah. On leading questions, which is really a benefit to the defense, you know, I mean, maybe they can get her to say some really outrageous things on cross, but we didn't ask her anything outrageous leading on direct. She didn't have any trouble with that at all. She just told her story, not mine, hers. Now they wanted, through leading questions, ask her their story, and they can probably get, maybe she will get the green cheese answer. I'm sorry about that, but that could happen. Thank you, Judge. Appreciate the opportunity to argue the case.
I'm going to give you another opportunity, Mr. Chavon.
Speak to her.
I will give you another opportunity to speak after I finish researching.
Judge, I truly understand the position of the prosecutor. Excuse me, Judge.
All right, Mr. Chavon, you now have my full attention.
Thank you, Judge. I understand the state of Ohio is in a very difficult position right now, Judge. I understand that. But with all due respect, this is not a game. This is not a competition between myself and the prosecutor. This isn't my opportunity to crush a witness in front of a jury and wave the victory flag. It's not what this is about, Judge. The fact is, the woman could not answer the court's questions truthfully, Mr. Moser's questions truthfully, or my questions truthfully. 601 requires the witness receive a just impression of the facts and transactions respecting which they are examined, or of relating them truly. Drugs, synergy, have nothing to do with it. And that's why we didn't go there during this hearing. We didn't need to, Judge, because synergy doesn't matter of the drugs. The effect of the drugs doesn't really matter. It's what she is testifying to The woman does not know what the truth is. She has stated that. She has demonstrated it. And Judge, I would ask that you find her not competent to testify. Thank you.
Ms. Rebecca Kenner appeared yesterday afternoon to begin her testimony. I'm not an expert on this, but she appeared in the manner in which she answered questions and responded and acted almost as if she was under the influence of some type of drug. She admitted during the course of the cross-examination that she takes Prozac with Mecto. She indicated during cross-examination that it was for depression and bipolar. She indicates to this morning during the competency hearing that those drugs do not affect her ability to think, understand, make important decisions, and I presume respond truthfully to questions. She indicates that she understands the difference between the truth and a lie. Yet, she readily admits she has difficulty responding truthfully to questions. Truth does not necessarily get in her way or become a filter for her to use in calculating her response to questions. That's a problem under Evidence Rule 601. That's a problem under 2317.01. I was asking the questions of her and trying to interview her this morning. Sure, it doesn't show up on a paper record. She's not acting in an aggressive fashion towards her. She's a soft voice. And even under those circumstances, when you're in a courtroom and the judge is asking you questions, you appear that she did not answer my questions truthfully. She would later recover, well, I don't know why the doctor prescribed to me Lamictal, and that's why I said I don't know as to why she prescribed Lamictal. But she just told Mr. Schiavone yesterday it's for bipolar. 2317.01 reads, all persons are competent witnesses except those of unsound mind and children under 10 years of age who appear incapable of receiving just impressions of facts and transactions respecting which they are to be examined or of relating them truthfully. And almost that exact same type of language is used in Evidence Rule 601. The court finds that Ms. Rebecca Kenner is incapable of relating just impressions of the facts truthfully and declares the witness to be incompetent to testify in this matter. So now, what, if anything, do you want me to tell the jury regarding her testimony? You want me to strike it, Mr. Schiavone?
Your Honor, I would request at this point a relatively brief recess so that we may evaluate exactly what's going on before I make a request, a formal request of the court. And I would request it.
Well, in light of that ruling, which I'm sure the state objects to, and I understand that, what would the state suggest that this court proceed? Strike the testimony, call an next witness?
First of all, Judge, you didn't hear me say I object to what you did.
Well, you might.
No, seriously. You're the judge. You make decisions. You make rulings. You're the umpire of this operation, and you call the shots. You made that ruling, and I made my argument, and that's the way it goes.
Fair enough. Now, how would you suggest the court proceed?
I think the appropriate way to proceed would be to instruct the jury that this witness is not going to be testifying further, that everything that she has testified to prior to this, in all respects, be stricken and move forward, because I don't think that if she's incompetent today, she's certainly not competent yesterday. I would assume that's the court's ruling, and that the only appropriate way would be to inform the jury that her testimony is stricken. I don't believe that, however, that it would be appropriate to give an explanation of medical issues and or judicial issues with respect to rules of evidence and things of that nature. I think it is appropriate to inform them, just as you have always done. Whenever you have stricken it, you don't tell them, and I'm striking this because of this argument or that argument. It is merely a statement that the court makes. They're required to do that, and that's how this case should then proceed, and we would like to move forward. Thank you.
I'm inclined to proceed in that fashion, Mr. Shimoda. So if you've got a different course of action, I think now is the opportunity for you to place it on record.
May I have a moment?
Yes.
Your Honor, I will renew my motion to strike the testimony of Rebecca Kinner. I agree with the State of Ohio that that would be the proper course of action. However, I believe the jury has a right to know that Ms. Kinner was found to be incompetent, and based upon that, they should disregard her testimony. The fear being that they just won't be able to remove it from their mind. The fear being that they're going to start speculating as to why. And I think there's a real danger in that. And I would just ask the court to...
What would the jurors do if I instruct them that he's incompetent? This is a legal determination. What would the jury do with that information?
Well, they would not be concerned that she became ill, or whatever any one of the 14 could conjure up in their minds as to why this witness is now being excluded. That's been a whole point. But yes, I do agree with Mr. Moser. The motion to strike is the appropriate remedy.
I'm not inclined to give the jury anything further than an instruction that they're to disregard her testimony wholly, completely. if they never heard it. And I don't intend to give them any further instruction at this stage. Yes, Mr. Roach.
Thank you. Your Honor, there's an open-ended motion, however, for mistrial. I would ask the court to either have that withdrawn or rule on that at this time.
Thank you, sir. I would withdraw our motion for mistrial.
It's being withdrawn.
It is being withdrawn.
Be clear. Fair enough.
Thank you, Your Honor.
And also, Judge, for purposes of the record, these decisions that were just made were made in consultation with Bradley Young, and he has consented to
Do
the course
withdraw the motion
for mistrial and to proceed in the fashion in which we proceed.
Wait a minute. I'm sorry. I guess I didn't hear what you
I'm
said.
sorry.
Can you repeat it?
I wanted to place on the record that we consulted with Mr. Young on these decisions, and that he has concurred.
Very good. Thank you.
Thank you.
All right. Now, Smart Gallery, thank you, ladies and gentlemen, for your cooperation throughout this trial. The jury's out. I'm going to ask for your cooperation once again. You might go out there and talk about rulings, things that's been made, or ever in the presence of the jury. But particularly now, I do not want to somehow, since that jury's sitting out there waiting on us, that they should somehow be exposed to improper information. You wouldn't be here unless you wanted to see that both the state of Ohio and the defendant receive a fair trial. So you're ordered not to go out in this hallway, out to discuss this matter in any form or fashion in the presence of the jury. Now, what time did you tell the jurors to come back, Rick?
They are waiting out there, Mrs. Reynolds is with them, and they're down together in the hall, however.
Is the state prepared to call second witness?
Sorry, what, Your Honor?
I believe he is 5 minutes away, so if we could just take a brief recess, we'll be ready to go.
You folks need a break? Yeah. 5 minutes.
Please rise.
5-minute recess.
Court's in recess, thank you.